Good morning, everyone, and welcome to Changes to NJ TDI and FLI and how they affect your business. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. With us today are Tom Foschino and Jim Iannicelli of Arch Insurance. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. If you just can't wait, you can download the slides right now from the Handouts tab, and our video presentation will be available today on our YouTube account at youtube.com/njbia. But I'd also like to draw your attention to the questions tab. Tom and Jim would be happy to take all of your questions, so don't hesitate to write them in as they come to you. And I can't stress that enough, write them in as they come to you, or you may forget what you wanted to ask by the time we get to the Q&A. So now let's get things started. Tom?
Thank you, Vinny, and thank you everyone for joining today. Today we're going to talk about changes that have happened in the state for the New Jersey Temporary Disability, or TDI, and Family Leave Insurance, which are better known as FLI. So we're going to go through an overview of what those are, for those of you who may not be familiar that much with how they work. We'll review some recent law changes that are affecting both TDI and FLI. We'll discuss your options as an employer, and we'll talk for a minute about what Arch's solution is for private plan for New Jersey FLI. So just to start here, there are several states across the country that have mandatory disability, and some now with FLI for all of the employees in the state. California, Rhode Island, Hawaii, New York, and New Jersey have been kind of the pioneers in this. And now we're starting to see more states coming on. Massachusetts, Washington State are starting to come on with similar laws for similar coverage for the employees of the state. So in New Jersey, from the smallest employers, and if you recognize the Wildwood Boardwalk on the left, you have many small employers there, many of them seasonal, to the largest companies that you have in the state, all of those employers are required to have this coverage for their employees. There are a few exceptions for some governmental employees, but for the most part, really all the employers in the state must have this coverage. So let's start with New Jersey Temporary Disability, or TDI. So what really is this? So what this is partial income replacement for employees who are unable to work due to a non-work related illness, injury, or generally a disability. Something where a physician has said that you are unable to work, for a reason that they can document, and you will receive some income replacement. So today, that benefit, or an employee can receive 66 2/3 of their average weekly wage, up to a maximum of $650 per week after a 7-day elimination period. That maximum duration is 26 weeks. So if an employee has an illness that or an injury that obviously is somewhat severe, you could see that going up to a maximum of 26 weeks. What we see mostly in this is this coverage is mostly used for maternity, pregnancy, or childbirth. You can also see off-the-job accidents. You broke your leg skiing, or an extended illness, severe flu. So those are the kind of things that we would normally see for someone who's out on a TDI benefit. So family leave is different. This is really this is time off that an employee can take to really care for others. Bonding with a newborn or adopted child, this is called child bonding. This is where mostly this benefit is used, and it's really up to the employee on how much time they want to take off. They do need to provide documentation of the newborn or adopted child, and this is, again, to care for someone else. So this is male or female, can take, the father or mother can take this benefit. There's also caregiving services for an ill or injured family member. Again, there is some documentation that needs to be provided if an employee wishes to take this leave, but But again, an employee could take time off to care for, a sick parent or something who needs to go for certain treatments every week. This has the same benefit as TDI. An employee can receive up to 66 2/3 of their average weekly wage to a maximum of $650 per week. The maximum duration on this in 2019 is 6 weeks in a 12-month period. So on January 31st of this year, both houses passed legislation number 3975. You may have heard of it, and it was signed into law on February 19th. And there was many changes to these TDI and FLI laws that went in place as a result of this. So we're going to look here at family leave first. No, that's not my child's baby picture, but sometimes I feel that way. So the changes in family leave are increasing from a maximum of 6 weeks to 12 weeks. And this will be effective on July 1 of 2020. So that's doubling the amount of time an employee can take for family leave. There's an increase in benefits from 66 2/3 of an employee's average weekly wage up to 85% of their average weekly wage. And that as well goes into effect on July 1st, 2020. The maximum weekly benefit is increasing from $650 a week to $881 a week. You can ignore that estimate. We have that confirmed now. When we wrote this, that was still unconfirmed. But that jump is what they wrote into the law, as the old law had 53% of the New Jersey's average weekly wage. That was the maximum. That has been moved now to 70% of New Jersey's average weekly wage. That's where the 881 comes into place. Another important point here is that employers with 30 or more employees must now offer family leave benefits. This is a change from 50 employees. And that went into effect this past July 1st. This is an important point for those employers who have between 30 and 50 employees. Their employees were not able to take family leave benefits. Well, now they are. So that's something that employers need to adjust for, just knowing that their employees do have access to those leave benefits. The waiting period has been eliminated. Employers are no longer required to use existing paid time off prior to using family leave. And I know we've always received a lot of questions on that. So that is part of that law. And intermittent leave is now allowed. So for example, an employee wants to take every Friday off because of certain services that they need to maybe take a sick parent to or something, or a certain day a week or something like that. So you can, intermittent leave was not eligible in the past, but now that is. So there have been some changes in the definitions as well. So family member, this is a little long, but I'll just kind of go through this a bit. So it means child, parent, parent-in-law, sibling, grandparent, grandchild, spouse, domestic partner, or any other individual related by blood to the employee, and any individual that the employee shows to have close association with the employee, which is the equivalent of a family relationship. So that's really wide open. And those of you who have your coverage through the state, and when an employee is placing a claim, they'll have to provide some proof of that relationship, but that definition is definitely wider than that was in the past. As well as the expanded definition of a child. So obviously biological child, adopted, foster care, resource 12 child, family child, step child, or child of a child who becomes the child of a parent pursuant to a valid written agreement between parent and the gestational carrier. So again, you've got a wider definition of child. And all of these definitions relate back to what I was explaining earlier about the different types of leave for child bonding or caring for others. So this kind of opens that up. As well has now eligible to take 20 days under the New York Security and Financial Empowerment Act, or New Jersey SAFE Act, to care for any individual in the event of a domestic violence or sexual violent incident. So there's been a lot of increases here to the benefits, across the board on family leave. So who's really paying for those increases? And this is really coming from the employees through higher payroll deductions. And we're going to go through those in detail and how these deductions change, really starting in the beginning of 2020, forgetting what year we're in here. Let's cover temporary disability. So everything I just said up to this point was family leave. And so now I want to go into the changes that affect temporary disability, or TDI. Let me kick this over to Jim here, and he can kind of explain some of these changes.
Well, thanks, Tom, and good morning, everyone. As Tom previously stated, there were, in addition to the family leave insurance, substantial changes to the temporary disability program made recently. So we can look at the grid here, and you'll see as of today, the benefit of payout amount, the percentage of the average weekly wage is 66 2/3%. That figure is going to 85% of an employee's average weekly salary beginning July 1st of 2020. Also, there are significant changes to the maximum weekly payout that a worker can receive. Currently, the maximum that an employee can receive is $650 per week, which is 53% of the New Jersey average weekly wage. The state has done this in 2 steps. Effective 1/1 of 2020, the maximum payout will stay at 66 2/3% of salary, but will increase from $650 per week to $667 per week. The significant change will take effect as of July 1st of 2020, where the benefit will go to that 85% of average weekly wage, with a maximum payout of $881 per week, which is 70% of the New Jersey average weekly wage. So these are very radical changes that we have not seen before. Typically, it would just be the 2 to 3% change from 650 to 667, but this new benefit will kick in as of July 1st, 2020. To pay for the increases in benefits, what the state has done is they will be charging a higher rate that employees will contribute towards the cost of coverage. Also, they have changed the taxable wage cap significantly for employees. So right now, employees pay 0.17% rate, but once they hit $34,400 in annual wages, they no longer contribute. Effective January 1st of 2020, the employee rate is going from 0.17% to 0.26%, and also the taxable wage cap will go from $34,400 to $134,900. So employees will pay that contribution amount until they hit $134,900 in annual earnings. The employer will also see a slight increase in costs, and it's strictly based on the taxable wage cap for employers going from $34,400 to $35,300 effective January 1st. So it's a much smaller increase for employers. The bulk of this change in contributions will come from the employees. And what I would just want to inform everyone, most of the larger payroll companies, if you use a payroll company, are aware of these changes, but it's never a bad thing to notify your payroll provider of these changes so they begin to deduct from employees January 1st the correct amount, the correct and also the correct taxable wage cap, or else you could kind of end up with a mess on your hands. So I would just encourage everyone to either notify your payroll provider or take note of this if you do your payroll yourself. It's very important. There's also a partial disability element to this coverage, which is currently pending. Right now, an employee has to be deemed as being totally disabled from working by the treating physician to receive disability benefits. That's been since the law was enacted in 1947. Currently there's legislation to change to a partial disability coverage for 8 to 10 weeks after 7 days of total disability. So if an employee could come in, they typically work 8 hours a day and the doctor feels they can work 4 hours a day, they would be able to come into work, get paid for those hours, and receive disability for the wages they earned while partially working. Another huge change to the law is, again, since the inception of the law from 1947 through February of this year, in order to move out of the state plan to a private carrier, an employer would have to have an election and have at least 50% plus one of their workforce sign written consent to move to a private plan. It became very difficult. A lot of people are not working under the same roof anymore, and we brought that to the state's attention, and they ultimately removed that requirement. So now an employer can move from state plan coverage to a private plan without the employee election being completed. So that's a huge difference in the law.
Okay, so let's take a look at who insures and who pays for TDI. So in New Jersey, every employer who starts in the state from inception, they're automatically put into what's called the New Jersey State Plan, and so it's just, essentially they're providing coverage. You're making contributions, like Jim had just gone over. You're making contributions, the employer and the employees, to the state plan, and when an employee is placing a claim for disability or FLI, they send it to the state, and the state sends them the claim checks, as we were just discussing earlier. Now, a small percentage of employers do opt to go to a private plan, and we're going to drill into this in a little more in a minute here. But you can see that the large majority of the employers in the state are with the state plan. The state of New Jersey sets the rules. So they set the rules that everything that Jim went over on contribution rates, how much the employees pay. They set the rules on the benefit for all the employees in the state, whether that's with the state plan or a private plan. So they basically set that bar there. The employees and the employers together are the ones who pay for the coverage. So as Jim just went over, so the employees will be contributing 0.26% of an employee's total wages up to a maximum of $134,900. The employer's contributions can vary year to year, and it's based upon the claims experience. So if you have a company who has never placed a claim with the state, you have a very low rate with the state. If you are an employer that has placed many claims, well, it's the opposite. You're paying, much higher premium each year for the coverage that you're receiving. So how much is everyone paying? So the state sends out, now again, this is for those of you who are covered through the New Jersey State Plan. You receive in the July-August timeframe a document this is a copy of one here on the screen. It's called a Notice of Employer Contributions. On this form, you can see on the very bottom, highlighted in red, that this final disability insurance rate is there. And this particular one is 0.65%. So that's where you find out what your rate is, and as well the overall employer contributions that this is based off of is there, and also highlighted in red in section K. But this is something that some of you have probably never seen this. Other of you have, you receive it in the mail, either you file it or you throw it away. But this is where you know what your rate is, and like I said, the state sends it out to you every year. So on the right side, you can see we've got something here laid out where all the way on the right, it's a state employee rate. And then next to it says state employer rate. So this gives you an idea of what employees are paying and what the employers are paying towards essentially this insurance premium. As you can see up and down that graph, all the employees pay the exact same rate. And like I just said earlier, the state sets that, and that's set for all employees. But on the column next to it, on the state employer rate, these are the rates that you could have with the state plan. So all the way at the bottom, the 0.10%, that's the best rate an employer could have with the state. That means that you've had very little or no claims at all for your New Jersey TDI. All the way at the top, the 0.75%, that's the highest rate you could have. That would be an employer who has placed a lot of claims with the state for their TDI. And so you're somewhere in that, and what the state is doing is going through an underwriting process. They're looking at your experience, so it's basically the claims that have come in and the total contributions, and they look at it and say, okay, how much activity does this employer have, and where should they be on this ladder of rates? So what I just talked about was what the state plan does, right? So we're going to look at what an employer has, what kind of options that they have. So every employer in the state, like I said earlier, automatically goes into the New Jersey State Plan. But they do have options. They can leave that state plan, and they can either get their coverage through a private insurance carrier, or they can choose to self-fund that plan. And that basically means that the employer is going to provide all of the funding for the plan, and they're going to pay their own claims, usually with the help of a TPA or something. But it is something that you can do. So employers again have three options: stay with the state, leave the state, go to a private insured plan, or you can self-fund. So why would an employer move out of the New Jersey State Plan? There's a potential cost savings. As you remember on that prior slide, you can go, you can have a certain rate with the state. Well, a private insurance carrier will look and maybe at some different factors here and may be able to offer you a cost savings of what you are paying with state. Now, this is on what the employer pays, not what the employees pay. You could also leave the state plan for improved claim and customer service. There are many insurance carriers in the state that provide private insurance for New Jersey employers for this coverage. Private insurance companies, they pride themselves on their claim responsiveness and their customer service. That's why they're in business. So that's another reason people would leave the state plan. Another thing a private or a self-funded plan could do is if you wanted to offer enhanced benefits, so a higher benefit than what the state is offering, that's your option. You can always do that. So if you wanted to be more competitive in the marketplace, and might be in a more competitive field for employees, you might want to offer enhanced benefits there to kind of bolster up your employee benefits package. So how does an employer do that? How do they move to a private plan? Number one, you have to get a quote from an approved insurance carrier that's approved with the state. It's signing the appropriate documentation and application. And then, as Jim was talking about earlier, your payroll services control a lot of this, right? So these things are funded through payroll contributions. That payroll company has to know that they're no longer to be sending those deductions to the state. They're going to be sending them to that private carrier. So why does this graph look like this, where it's 98% of employers are with the state and 2% with private carriers? Like I said earlier, everyone is automatically put into the state plan, so that's just where everyone starts. A lot of it is knowledge. We talk to a lot of employers throughout the state, and a lot just don't know that you have that option to move out, and that you can do something. And for some employers, it's better. They may have that option to move that. But I left on here something from an old slide, this employee consent election that Jim was talking about earlier. That was a big barrier to a lot of employers that wanted to move from the state plan to a private plan, but trying to get the appropriate number of signatures was just a monumental task. But as Jim had mentioned earlier, that piece is now removed, so it makes it a much easier flow for an employer to shop the market and go out and see what's the best deal for them, either staying with the state or you're shopping, like you would any other insurance plan. So let's talk about ARCH and NJBIA and why, what we're doing here. ARCH Insurance, many of you have been at events or, through the magazines and stuff may have seen ARCH. So we joined up and became a partner with NJBIA in 2016. And so we do a couple things here for members. So we offer special pricing for NJBIA members that a non-member would not be able to get through ARCH. We offer something called, basically it's kind of like a rate protection, or we stabilize employers' rates. So what we do here is all the members, NJBIA members that have a policy with ARCH, they are all put into one, what we call insurance pool. So we don't raise rates for individual employers unless the entire pool has gone over a certain threshold. So what that does, that really kind of gives you the power in numbers. It really kind of helps employers get something special in rate protection there. They wouldn't be able to get outside of, belonging to an organization like NJBIA. ARCH pays what's known as the annual assessment fees. So we take care of that. There's no additional cost to employers for coverage for this. As we said earlier, the state sets the rates, and we cannot charge any more to employees than what they pay through the state. We pride ourselves on fast claim services. The state, in their own admission, in their own reports, averages up to 25 days to look at and pay a claim. We look at claims and pay them within 4 days or less. We reach out to employers, or physicians if there's anything, incorrect or illegible on a claim form or what have you. And ARCH does have some online services, online reporting services, which are nice, which can come in real handy for employers when they are, trying to manage who's out on disability.
I just wanted to jump back real quick where Tom spoke about the insurance pool. So some people might be asking, well, so what happens if I join this pool, I pay into it, I don't have any claims or minimal claims, but the overall pool does not, has worse than expected claims experience. So what we do is we put everyone into this pool, and as long as the pool runs within a specific, what we call a loss ratio. A loss ratio is claims versus premium in. I'm not going to get too technical, but if the pool runs well, nobody gets a rate increase. However, if the pool goes above the threshold, only the groups that had the high claims experience are affected. So I just wanted to be clear on that, that if you have very good claims versus premium ratio, your rate would not change even being a part of the pool. So it's kind of a win-win situation there. So.
Okay, so we spoke earlier about this ladder of rates that the state has, and I just wanted to just let you know, we don't want to get too much into talking about our plan here, but I just will let you know here that what we do is for employers with 250 employees or less, we have special rates that are already set up with the association, so that, you know, we talked earlier about that, you know, what your rate is with the state. And so what we do is we look at, if you will come to us and say, well, what would you charge me? We would look at that, the rate that you're paying with the state. And let's say you have this bottom one, the 0.10 highlighted in red. We have a set table here. If you're at 0.10, we're not going to charge you anything. We're simply going to pay the full premium of the plan just through the employee contributions. So it's 100% savings for the employer. If you have a higher rate, let's say you have the 0.25%, the arch rate would then be the 0.19. It's a 24% savings still for the employer. If we have even a higher rate, a 0.40, we're charging 0.37, and this is an 8% rate. Again, this is for the employer on how much they would pay. So it's still a good savings there. Now, if you have a much higher rate, I got here this 0.60, that doesn't mean you can't take advantage of one of our plans. We just go through what we call an underwriting process. We'll look at your claims and how much premium you've paid over the last few years, and then we'll see if we can still offer you something better than what you're paying with the state. If you have more than 250 employees, we automatically go through that underwriting process. And I guess, like I said, it's all based on how many claims you've had and how much premium you've paid in the past, like any other insurance you have, your health insurance, your dental, your fire, your theft, everything else. So, so that's what Arch is doing for the NJBIA members here. So what we're going to do, I just want to recap real quick, and then we're going to open up to questions. I know many of you have been sending questions in here. So just to recap, we've gone through the changes to the New Jersey Temporary Disability, or TDI, and the Family Leave Insurance, or FLI, what those benefits are. We've gone through the changes in leave definitions. I think those are important to understand. We've gone through the changes in the amount the employees and the employers pay, you know, in 2020 versus what they're paying in 2019. We went through your options as an employer. You're with the state plan, you have the options to go with a private carrier or to self-fund. The elimination of the employee consent election and what that means for you as an employer, gives you some more freedom to shop the market for the most appropriate coverage for you. And then we reviewed what Arch's solution is for a private plan. Oh, one other thing I just wanted to mention here. So there are other states here, on some that are bordering. So New York has a similar plan to New Jersey. So if you have employees in New York, they have a disability plan as well as a paid family leave. I did highlight here Massachusetts. For those of you that have employees, maybe have an office in Massachusetts, you should know that a very similar plan is coming to Massachusetts starting in 2021. However, all those employee contributions started this quarter. So employers there are already starting to pay into their coverage. There are options to, again, it's a state plan. Employers do have the option to move to private carriers or self-fund there as well. So it's just important to note, if you have employers up there, you should really look into it. We're now working there as well. So if you have questions, you can also contact us to get further information on that. All right, so Vinny, so why don't we take it over to some questions?
Okay, so we have a couple already, but I want to give everyone a second to type in anything they've got. While I'm doing that, I'd like to take a second to remind you about the Handouts tab. People always seem to ask how they can download the slides, so just open up the tab marked Handouts in your GoToWebinar panel, and the PowerPoint file is right there. You can also just wait until tomorrow, and I'll email them to you along with the video of today's webinar. And there's the Questions tab. If you have a question, type it in right there, and I'll make sure our guests answer it. And don't be shy. You've got two experts here, so make sure to take advantage of them. Can't tell you how many times I read the post-webinar evaluation survey, and I read people who are like, oh, I didn't get what I came for. You know, it was too in the weeds, or it was too broad, or they didn't cover this. This is your opportunity to take the webinar in the direction that you want it to go in. So by all means, with that out of the way, we're going to jump into our first question that comes from Kate, who asks, do the employees have to be full-time? And if so, what qualifies as full-time?
Great question. Yeah, in the state of New Jersey, all employees must have the coverage provided to them, regardless of someone who works 5 hours a week or works 40 hours a week. So again, all employees must be provided this coverage.
Okay. Nancy just wanted a little clarification on this is partial, or for the NJ FLI, that is partial income replacement and not leave entitlement, correct?
That is correct. Excuse me. Yeah, this is strictly a paid family leave component, which is much different from the Family and Medical Leave Act. So it is a partial income replacement to care for a family member, excuse me, or to bond with a newborn.
Susan actually had two very similar questions, so I'm going to ask them kind of back to back here. But the 12 weeks, that would be for family leaves beginning on or after July 1st, 2020?
Yes, that is correct. The event would have to begin on or after July 1st of 2020.
And then the second part of her question, she wanted to ask if the increase in TDI is for disabilities that start on or after July 1st, 2020.
Yes, same thing. It would be the first date of disability would have to be on or after July 1st, 2020 to receive those additional benefits. It's not for a claim already in progress.
So this next one from Kenneth kind of goes back to what Nancy was kind of talking about, but he asks, will I be able to take every Monday off to bond with my new baby because my wife works Mondays and I want to care for my baby? Is that now protected?
Yes, that would fall under the intermittent definition of the paid family leave. Mm-hmm.
Siri asks, any idea when the partial disability rule will be decided upon?
Unfortunately, we don't have an answer on that. These things are still being debated, by the legislators, I should say, and we unfortunately don't have a time frame at current.
Okie dokie. Sharon had actually asked a question that you then answered maybe like 3 seconds after it came in, But just in case that there's like some overlap here where maybe it wasn't fully covered, I'm just going to throw it out anyway. So Sharon asks, what about employers with over 250 employees? How does Arch calculate their percentage?
Yeah, good question. So, right, what we do is we underwrite the the account. So what that means is that we look at claims experience that you've had over the last few years and the premium that you've paid, and we evaluate. We look at the makeup of the employees in your company and such, and we go through what's known as an underwriting process to come up with a rate with that. So that is something that we commonly do. That those rates I was showing that were below 250, that's like a special thing we have in place. And because obviously there's more companies under 250 employees than there are over, it's kind of helps us move through those much faster.
Michelle asks, with a private plan like this, are employees still making a contribution or is it entirely employer funded?
No, the law does state that the employee contribution applies to state plan coverage, private plan coverage, or self-insurance. So employees would continue to contribute for a private plan. I'm sorry, just to elaborate on that a little bit, the employer does not have to take the employee contribution, but they are legally allowed to take that contribution. So.
Lisa asks, for the FLI, does the 30 employee minimum get based on the number of employees who are actually working in New Jersey?
Yes, this is all predicated upon employees working in New Jersey. Yeah.
Sort of an inverse question then. Michelle asks, can private plans also offer coverage to employees outside of New Jersey?
No, unfortunately, we cannot. We were advised by the Department of Labor and Workforce Development that only New Jersey workers are entitled to both the disability and the paid family leave coverage.
Cool. Linda asks, when does the provision that you can no longer require employees to use paid time off time before FLI go into effect? When does intermittent leave for the FLI go into effect?
Yeah, I believe that was July 1st of 2020. Yeah.
Okie dokie. Sharon asks, can an employer still require an employee to use paid time before using TDI?
Yes. Yes, they can.
That was a quick one. Okay. Christine asks, you mentioned the waiting period is eliminated for the NJFLI. Is that a 7-day waiting period or employment of 1 year or 1,000 hours, etc.?
That would be the 7-day waiting period before benefits would be paid. That's going to be eliminated.
Here's another one from Sharon. Can we supplement FLI and TDI benefits with paid leave to make employees whole on salary?
Absolutely. Yes. So in that instance, when a claim is submitted, we ask that question, will an employee receive any type of wages while they're out? And then we have a follow-up question, are the wages that will be issued to supplement the difference between the disability payment and the regular weekly wage? And absolutely an employer can do that. Mm-hmm.
I have a question from Will here who wants you to explain the rate protection for NJBIA members again.
Yeah, so basically it's seen as an insurance pool where all of the premium and claims go into one, um, for lack of a better term, bucket. And then what we do is we monitor the premium in versus claims paid out for the entire association. And so even if let's say a small employer may have a bad claims year, they have a couple claims. If they're with the state plan, there's a good chance they would get a rate increase. But because they're part of a large insurance pool, as long as the overall uh, pool experience is doing well, that employer would not see a rate increase. So it's kind of a strength in numbers mentality. You become part of a larger insured group.
Kate asks, what is the max amount of time an employee can use these and still have their jobs held?
Yeah, that's a tricky one. There are various laws. There's nothing within the disability law that says a job has to be protected. However, on paid family leave, it does kind of fall within the Family and Medical Leave Act, which does offer some protection. Personally, I'm not that versed in those protections, but I believe it's 12 weeks of job protection. But that's something I would have to look into further. And if Kate wants to drop us an email, I'll certainly get back to her.
Great. NECA asks, what is the effective date of the elimination period on TDI?
So for disability, what happens is when someone goes out on disability, they're not paid for the first 7 days that they're out. However, under the law, if a person is out for 21 consecutive days, if they're deemed as being unable to work for 21 consecutive days, they receive that waiting period back. So the only time a person would have a 7-day period where they're not paid is if they were out for less than 21 days in total.
Sandra asks, if an employee is on TDI, do we as an employer have to mail the employee a letter stating that we are counting the days of their leave? Does this tie in with FMLA with the 12 weeks unpaid job protective leave?
No, there is no requirement. Basically, what employers have to do, for disability is just cooperate in the claim process, fill in any forms asking for employment data. But other than that, they can't withhold these benefits from employees. What every employer is supposed to do is to post a notice for employees advising them of their rights under the law, but that's basically the only requirement the employer has. So.
Melissa asks, can employers require staff utilize their time off supplementally?
There was something that came out. I believe it was 5 days of sick time. That's another one I would ask that someone email into us, and we can look into that further.
Okay. We had a couple in a row here come in about intermittent leave, so I'm going to take the wording from one of them. NECA asks, what is the new definition of intermittent leave? I understood you have to use under 8 weeks of leave and it is considered intermittent. Is this correct?
So the intermittent leave can only add up to whatever the benefit maximum is, which is currently 6 weeks going to 12 weeks next year. So if you were, um, if it's 6 weeks, that would be roughly 30 work days. So if you took every Friday off, you would be able to take 30 Fridays before you hit that benefit maximum.
Okay. Gordon has a question here that I think we may have just covered, but I'm going to throw it out anyway just to give Gordon some peace of mind. Under PFL, if I take leave, is my job protected?
Again, that falls under the Family and Medical Leave Act, and there are some job protection requirements that uh, that oversee the paid family leave as well.
Cool. Mary asks, what are the pros and cons of using private/self-funding, and what is the process to do so?
Yeah, good question. So, one may opt to leave the state plan to go to a private plan or self-funded. To number one, just generally cost savings. Um, the state has a set amount of rates that they can offer, and they can only go so low. You may have experience that you can get a much better rate outside of the state plan or through self-funding. So there is obviously the cost savings right off the bat. Number two is customer service, and that is always very high on the list for especially many HR managers. Just being able to get someone on the phone when you have a question about a claim, um, having claims processed quickly is paramount, certainly for an insurance carrier, and certainly if you're self-funding. um, you know, that process, when you have an employee who's going out on disability, this becomes their income. And so you want them to be able to get that pay quickly. And so, like I said earlier, even through the state's own admissions, they've been having, long backlogs in processing claims, which just makes the wait time much and much longer for employees. Then the third piece there is if you wanted to enhance benefits, if you wanted to have a higher benefit for your employees per week, you can certainly do that, but you can't do that inside the state plan. You have to do that through a private carrier or through self-funding.
Michelle asks, will the reporting be changed to NJFLI to accommodate intermittent leave reporting?
Yeah, well, the assumption would be that the claim forms will be updated where it would be asked if the employee was taking a continuous leave versus an intermittent leave. And typically what we say is, if intermittent leave, what are the, is it a particular day per week, or, is it 2 weeks and then back to work for 2 weeks and then back out again? We haven't seen the updated claim forms as of yet, so that's to be determined, but New York has a similar element to the coverage of intermittent leave, and that's what we've seen there. So
NECA asks, on the private plan, does the employee contribution still come out as a tax on the employee paycheck?
yes, it's the same deduction. I'm a New Jersey employee, and we have a private plan, and it certainly does come out. So I've seen it firsthand.
Joan asks, just to reiterate, an employer can still require employees to use 2 weeks paid time when going on leave?
Again, there were some changes that I saw last year. That's something I'm going to have to. I don't want to give a definitive answer on because I'm not sure if it's 2 weeks, if it's 5 days. So that's something I'm going to have to look into further.
Okay. Nancy asks, to clarify, I thought that the New Jersey Family Leave Act applies to employers with 30 or more, whereas previously it was 50 employees, and it's 30 employees worldwide, correct?
No, it's all based on New Jersey workers. That's the determining factor, how many New Jersey workers an employer has as far as what their coverage requirement is.
Here's one from Lynn who asks, when the employer pays employees a partial salary while on disability, does this reduce the state disability payment?
Well, yes, it certainly can. If you know, in many instances, the employer pays the difference between the regular salary and the disability benefits. However, if an employer pays more, that would subsequently reduce the benefit, and there would be less paid claims charged against their account. So.
Rachel asks, what if I want to go back to the state plan after being with the private plan?
Yes, so you always have the right to go back to the state plan. There is a notification required of 30 days prior to that return date that would have to be sent in to the state of New Jersey before that could take place.
I've got two more questions on the table here, but if you ask more, we'll keep it going. So here's one from Lisa who asks, for FLI, you can't require an employee to use their PTO, but what if they voluntarily ask for their PTO time during the time they are receiving insurance?
Well, I believe the employee can never receive more than 100% of their salary in the paid family leave benefit at the same time. So any payment would have to be the difference between the paid family leave benefit and the regular salary.
Okay, here's the last one. Can the employee deduction be part of a Section 125 cafeteria plan? Asks Deborah.
I want to be very honest. I've never heard of a Section 125 cafeteria plan. I'd be glad to research that if someone would want to send an email over to us.
All right, well, that seems like a good enough place to leave off. So don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. Lastly, when you close out of the webinar, a survey will come up on your screen that we hope you'll fill out so we can understand how to best provide you important information in a webinar format. Our next webinar, Cyber Insurance, Potential Liabilities and Current Trends, will take place November 6th. So by all means, feel free to register for that one right on our website at njbia.org. So until next time, for Tom Foschino and Jim Iannicelli, this is Vinny Civitello thanking you for being with us this morning and wishing you a great day.